Hi guys, and welcome back to Contract B. This is video 2 for topic 10, and in this video we will look at the last of the remedies, so that is equity and probably also remedies under the ACL, although if the video is getting a little long I may make that a separate video. Good news for both of these topics. I'll be taking a fairly light touch because we have discussed equitable remedies before, and you should be fairly familiar with them. So this is more of a recap than anything. Similarly with remedies under the ACL, certainly for the consumer guarantees, I understand that you did those in Contracts A, so that should be more of a review session for you. And also the remedies available for the unfair contract terms provisions. You've also done those in Contract A. So really the remedies under the ACL that I want to concentrate on for this last part of our remedies discussions will be the remedies available for breach of Section 18, the misleading or deceptive conduct provision. I also want to have a little look at some of the ragtag bunch of other miscellaneous remedies that are available under the ACL that you may not have had a chance to explore just yet. So looking first at equitable remedies. First up, there's a couple of things that you need to bear in mind as we go through our discussions on equitable remedies. And the first big one is that equitable remedies are not going to be awarded if common law damages are going to be sufficient. Generally speaking, when you're talking about contracts, the most natural and fitting remedy will be common law damages, okay? That's just the way things are in terms of contract law. It's really only when damages aren't sufficient to compensate for the other party's loss or inconvenience that you're going to look to the equitable remedies sides of things. The other thing is that unlike common law remedies, equitable remedies are discretionary. So the court's going to have a good long look at the conduct of both the defendant and the plaintiff when they come to court and seek an equitable remedy. So you've got all of those equitable maxims that we were talking about at the beginning of semester cutting across the plaintiff's right to ask a court for an equitable remedy. So where you've got things like unclean hands, that's going to knock you out if you're a plaintiff asking for an equitable remedy. So bear those two things in mind as we go through our discussions now. Specific performance. Okay, we all know what an order for specific performance is. It's an order by the court that a party perform a particular contractual obligation. Again, not available where damages are otherwise appropriate. It's usually awarded in situations where the object of the contract, whatever is bargained for, is particularly unique, and as such, damages aren't monetary compensation, isn't really going to square the plaintiff off, okay? It's not going to really compensate the plaintiff for their loss. Land contracts, because all pieces of land, all plots of land are unique, it's a prime contender for an order for specific performance. Anything that, any contract that involves something that is not readily compensable by money will be prime contender for an order for specific performance. So where you've got agreements to lend money, agreements granting a license, particularly a license over land, these are not going to be the kinds of contracts that are amenable to an order for specific performance. Also, a court generally won't award an order for specific performance where supervision is going to be required. If the contract is of a very close interactive nature between the parties, and the court would basically have to step in and perform the role of policeman in making the parties continue this contract and perform their obligations properly, it's probably not going to work. So here we just have the case of J.C. Williamson and Lucian Mulholland. So in this case we have the lessees of a theatre making an oral agreement with a confectioner that they had the exclusive right to sell a number of things in the theatre that we all like to eat: ice creams, confectionery, soft drinks, and so forth. The lessee repudiated the agreement, and the confectioners didn't really want to stop selling all of such goodies at the theatre because, as you know, it's a rather lucrative business. Everyone's paid $12 for a box of popcorn. Go figure. So they applied for an injunction and equitable damages as well as specific performance. Now, on the topic of specific performance, the court said, no, we're not going to step into that role of policeman between the parties. If we were going to force this relationship to continue, we'd always be involved because there was so many different issues that could be disputed between the parties in the course of performing. So the confectioner had to do things like ensure the appropriate dress of its employees, ensure the appropriate behaviour of its employees, it had to ensure the quality of its goods and so forth. Now, in that kind of a circumstance, you can understand the court's reluctance to make that relationship continue. Now, in terms of defences, the text goes through all of these defences in reasonable detail. I don't need you to know the real fine points of the detail. I really just need you to know what's listed here in terms of the various different kinds of defences that can be raised to the grant of an order for specific performance. And they're all the common sense kinds of things that you would think, oh, well, if that happened, surely they wouldn't grant an order for specific performance. So, for example, where the defendant that would otherwise be subject to the order has entered the contract due to mistake or some kind of misrepresentation on the plaintiff's part, or where enforcement would create undue hardship. Now, note that this particular defence is quite rare because, you know, any party that's the subject of an order for specific performance is going to suffer some kind of inconvenience. They obviously don't really want to perform whatever it is they're supposed to perform, and it's going to cause them some, inconvenience to do so. So what you have to show is quite strong evidence of hardship. Financial hardship, just pure financial hardship, is not enough. You need to show things like the usual equitable problems of undue influence or extreme one-sidedness in the contract that you are being ordered to specifically perform. Other defences are where the plaintiff applying for specific performance is themselves not ready, willing and able to go ahead and perform a contract. You can't have an order for specific performance, obviously, in that kind of situation, where performance is going to be impossible or futile. Or if the plaintiff applying for specific performance is guilty of laches. Obviously that's one of the equitable defences, so you're going to be looking at things like unclean hands as well. All of those kinds of equitable considerations will factor into the grant of an equitable remedy. Also where the contract is unenforceable due to informality. So, for example, I think the text uses the example of a land sale contract that's purely oral. If that's the case, then you may not get your order to specific perform there. So they are the defences for specific performance. Then we come to injunctions, and you might not have had a look at these much before, but everybody kind of already intuitively knows what an injunction is from watching Suits and listening to media reports and so on. Usually there's a two-step process, so you've got to get yourself an interlocutory injunction first. That'll preserve the status quo, and then you go on to have your hearing and ultimately, your grant of your final injunction. And to get an interlocutory injunction, you have to convince the court of three factors. Firstly, that damages are not going to be an adequate final remedy. Secondly, that there's a serious question to be tried. And here, basically, the court's just trying to get to the bottom of the matter. Well, is this really just a vexatious thing and this person's just run off to court to try and get an injunction just to throw a spanner in the works of whatever negotiations are going on? Or is there actually a serious legal question to be tried here? Is there some prospect that what the plaintiff is trying to argue could be finally upheld and a final injunction granted? Finally, the court has to engage in this weighing up exercise. What's the kind of prejudice that's involved to the plaintiff if we don't grant this interlocutory injunction versus what is the kind of prejudice to the defendant if we do grant this interlocutory injunction? And on the balance of convenience, if it comes down on the side of the plaintiff, then the interlocutory injunction is going to be awarded. Then you have the hearing for the final injunction, and if the plaintiff is successful there, they will get their final injunction. Okay, what are some of the issues? Well, we know injunctions can be negative. That's usually the case. So injunctions are granted to stop someone from doing something. In contract law, injunctions are usually granted to stop breaches of a contract. Okay, however, injunctions can be positive. And here they start to look a lot like an order for specific performance. So a mandatory injunction is an injunction that makes someone do something. Okay, usually you'll tend to ask for specific performance if that's really the basis of what you want. An injunction, the text talks about this. An injunction may not be granted to restrain breach of a negative stipulation if it's going to essentially force a positive obligation. And is your head reeling at this? I know mine was when I first came across this issue. But the Dalgety case kind of helps you get your head around it. Here we had a negative covenant, and the negative covenant there was in relation to a liquor license for a bottle shop. And what the lessee wanted to do was to remove the liquor license from this leased premises and transfer it over to some new premises that it had found only about 100 metres up the street. Now, obviously, the landlord wasn't too happy about that. The question was, given that parties in the plaintiff's position did actually have a statutory right to apply to the liquor licensing regulator to remove a liquor license from one premises and plant it onto another premises, given that the plaintiff had that right under a statute, was that the kind of thing that could be put into, as a term of a contract, put into the lease? And it had been, given that it had been put into the lease, was that covenant something that the court could stop a breach of? So could an injunction be granted to stop this plaintiff from asking the liquor licensing regulator to take that liquor license from the lessee's premises and put it into the lessee's new premises, contrary to what the lessor wanted? In that situation, you can see that a covenant not to remove a license is effectively like a positive obligation on the lessee to stay and to maintain that license for that particular premises. The court has a good look at situations where there had in the past been a reluctance to grant an injunction to stop breach of a negative covenant like this. And there had been comments by Lord Cairns in Doherty and Allman that equity has no jurisdiction to grant injunctions to stop a breach of a negative covenant. And Justice Mason specifically disapproves that and says, well, really it's a matter of balancing up all the factors as you would with any other injunction. So he has a look and says, well, the usual situations are injunctions are going to be refused where you've got things like contracts for goods or chattels. Well, why is that? Because damages are probably going to be adequate. Contracts for personal services, you've got that, interactive personal nature there. Also contracts requiring supervision, same kind of thing. Court's going to have to step in and play policeman. Injunctions not usually granted. In that situation, on the facts of Dalgety, they said what was the real problem in granting the injunction in that case was the fact that the liquor licensing legislation, the intent of that legislation, was that a licensee of a liquor license could actually apply through the statute to the liquor licensing court and ask the liquor licensing court to take the license from that premises and put it on another premises. Now, the court said in that circumstance, given that we've got a negative covenant in this lease to stop that happening, this is not really something we're going to allow an injunction for, because that lessee, under that liquor licensing legislation, should have the right to freely apply to change around that liquor license. So it wasn't the kind of thing that was open for an injunction there. Don't get too bogged down in this whole issue. It's not a real big one. There is just some debate in the text and has been some debate at court on this issue. I think it's just going to be a common sense approach, much like Justice Mason took in this particular case. Damages. Well, here we come to the last of the equitable remedies that we need to talk about. I don't want you to get too bogged down with damages either, equitable damages, because your head can start to spin after a while. The text is fairly short and sweet on this issue, and so I will be too. Really, all you need to know is this. You're normally going to seek equitable damages in addition to or in lieu of specific performance or injunctions. So where you're already looking for equitable remedies, you may seek equitable damages either in lieu of or in addition to those equitable remedies. Given the fused system of equity and common law, you can actually apply for equitable damages and common law damages in the same application or writ, but you're not going to get both. So, for example, you can seek specific performance and or equitable damages on the one side and then plead in the alternative common law damages. And if your common law damages are not going to be found to be sufficient or adequate in the circumstances, then you can fall back on your request for equitable remedies like equitable damages. If your order for specific performance is abandoned, you can of course fall back on your common law remedies, including common law damages. If you do get an order for specific performance granted and then the defendant later breaches that order for specific performance, you can then as a plaintiff go ahead and accept that as a repudiation. Okay, you're not going to proceed directly to equitable damages at that point. What you're going to do is accept it as a repudiation, and then the contract's terminated, and so then you're thrown back to common law damages. If your order for specific performance is refused, or if your plaintiff still suffers loss over and above whatever the order for specific performance can remedy, then at that point you can seek equitable damages. Equitable damages will be assessed in the same way as common law damages, so you are not thrown back on that nasty tortious measure of loss. You are looking at that nice expectation loss, the same way common law damages are calculated. That is the issue of equitable damages, and that is the issue of equitable remedies. And it's time to probably stretch our legs again, have a short break, and I'll see you back here once again for remedies under the ACL.